These are the respondents.
Okay.
Judge, as of today, Mr. Barngrover is $2,114 in arrear. He's ordered to pay $302 a month, asking that the court issue a contempt order for him and allow him to purge himself of that by paying $1,000 on or before March 23rd.
Okay. Look, electronically file the order, we'll sign.
I will.
Ray versus Cowan.
Judge, this was the Commonwealth's motion for contempt. The respondent came in yesterday and paid the full balance, so there is no longer an arrearage. That would be
Remove it from the docket. Was that one that's all arrearages and no current payment?
yes, they're current now in both respects.
Okay. Hey, it's taken care of. Thank you. Okay. Parrish versus Shawnee. Just Shaw hand rather.
Yes, Judge, I'm here for Ms. Shawhan virtually.
Okay, wait a second here. You need to speak up a little bit. Okay, what do you got?
Judge, this was another of the Commonwealth's motions for contempt. We received proof yesterday that her tax refund was garnished in the amount of $3,763, and she paid yesterday her February payments. She is current now too. So I ask that be removed from the docket.
Okay, any objection to that?
No, Judge.
Okay, thank you very much. That concludes
Thank you.
y'all's.
That's all I have, Judge.
Judge Mike Van Sickle for the defendant West Bend, appearing via Zoom.
It's a motion for summary judgment. I've read your brief here. What kind of, Mr. Wilkerson, what kind of response do you have?
Judge, we were able to file actually a response today. We were asking for, looking at rule, CR 5603, which is the notice requirement, for a summary judgment motion.
You need to speak up a little bit.
So, Judge, they filed their summary judgment motion on, February the 16th. It was late in the afternoon. We've not had an opportunity to fully prepare and get this,
Well, let me ask you something.
Yes,
I've
Judge.
knocked this case around for quite a while. What is their defense? They've been given an opportunity to provide proof that this was wrong, was wrongfully paid and that they made payments on it, but up to this point, according to the brief of the plaintiffs, they haven't shown where it was wrongfully paid. And then do they have any proof that it's wrongfully paid, or are we just kind of knocking this thing around?
I don't believe so, Judge. And the reason being is on two different fronts. You know, looking at this, prior to, this is an action on a surety bond, right? And so there's two.
Indemnification, right?
That's right.
Yeah.
Indemnification. And I believe the facts come down in two different buckets. And one of the buckets is, how did the claim get settled? The underlying claim that was made by a supplier against the surety, right? And how was that claim settled? And we believe that.
Okay, well, let's stop it right there. The underlying claim, okay, so this job was bonded.
That's correct.
Okay, and then the underlying claim is because your clients did not pay for materials. And so they, the plaintiffs went against the bonding company who had bonded payments on these things, received payments, but have never, you're saying it was unfair practice or something in settlement, but you never have shown any proof that your clients paid for this material and therefore the payment by the bonding company was improper. And I think that, I've read and reread this thing, and I think that's the crux of the matter. Now, and some of these other defenses you made under fair practice, I don't think apply to a commercial situation like this. I think the plaintiff is correct on that. I'm just asking you plain out, does your client have any proof, which has not been provided to the plaintiff, that they paid this and therefore the settlement which they seek indemnification for should not have been made? It's a simple question.
Well, the reason why it's not as simple is because.
It's a simple question for me that I want to answer.
There was, okay, so, but again, we have to look at this in two different buckets,
Well,
Judge.
this is the bucket I want to look into it. And if
Right.
you got an argument that will change whether they're responsible for it, I just want to know if your clients have any proof that they made the payments and the payment by the bonding company was improper and against their interest, and that they shouldn't be able to be indemnified.
The amount, Judge. So if we're talking about tip to toe, right, if it was like, there's absolutely no obligation to the supplier at the original outset of this, right? If we're saying that there is, the obligation was totally wiped clean by my clients before the bond company paid.
And they paid it?
Have they paid it
Did your clients previously pay?
prior? No, but the dispute is with regard to the amount, right? The dispute is with regard
Well,
to the
well, we
amount.
need proof as to the amount. You know, the proof is to the amount. If your clients paid half of it, then the bonding company should have just paid for half of it, and you'd be allowed an offset against this indemnification judgment. That's what I've got to know. Do you have any proof where your clients paid for any of this material that was supplied?
Well, in the course of discovery, we requested a myriad of documents to which West Bend has provided most, I don't know if all, but most. And inside that, there were invoices from the underlying supplier for the original claimant to the bond.
What proof do you have by your clients that they paid any of these bills? I don't think it's that incumbent upon the bond company that the bond company paid a claim for unpaid materials that your client they say did not pay. I don't know whether your client paid it or not, but I've seen no proof. All this time we've been jargling this case around. You've had an opportunity to come in and bring proof that your client paid this and that the bond company inappropriately paid that bond off. And I haven't seen any of it. And when I ask you straight up, you don't give me any numbers.
Okay, well, so yes, there were offsets. And so the claim wasn't about money actually having been paid. We believe that there were checks that were actually paid. The underlying claimant
By
is
your client, by your
by
client.
Consolidated Pipe, yes.
Is that your client?
Them or the person, the principal who would have been issuing the checks on the job, right? They would have diverted payments to Consolidated Pipe, which is the underlying claimant against the bond, the supplier of pipe. This is an excavation company. They were saddled with big jobs. Barron County Board of Education, did some stuff for Western Kentucky University.
Where's the proof that your client paid for these materials or someone paid for these materials on their behalf? Where is that proof?
We believe that there is at least some amount.
Well, what amount? See, this has been going on, this discovery has been going on and back and forth. You have to give them some discovery too. And we could end this case and get around all this stuff. If your client, are you saying your clients don't know how much they paid?
To be candid, no, we do not.
Well, that's a problem.
That is a distinct problem, and we've been earnestly trying to get to that. A lot of it also hinges on the amount of offsets. This Consolidated Pipe, the original claimant against West Bend's bond, they had a lot of different projects going on at various different times and also in conjunction with one another. I mean, they would have been, there was like a job in couple of jobs in Bowling Green, Glasgow. But again, Judge, that's not the crux of this. And what I'm saying is there were offsets. There would have been returned materials. And that we don't believe that there was adequate offsets provided.
You need to provide proof of that.
And we believe with the invoices that have been provided through the discovery that we requested, we've been able to at least make a showing of that. I'm asking today.
I haven't seen it yet.
Judge, and that's the thing. They filed this less than 10 days ago. And so under the rules, and I've cited the case in our response, I understandably it's a hurried response, but so is the motion itself. I mean, the rules clearly state that it needs to be more than 10 days. And so
And Judge-
also with regard to that,
Let's the attorney for the plaintiff speak here. Go ahead.
Judge, we've got no objection to allowing him at least 10 days, passing this for a hearing on another date and allowing him time to file an actual response to our motion.
Okay.
well, that sounds
Okay, you file one within 10 days from today.
a response.
A response, and in that response, I want you to outline the payments or offsets you feel like your client is entitled to. Is that unreasonable? I mean,
No,
this
Judge,
case,
but-
this case was
But
filed.
that's not the only issues at play here, Judge.
Okay,
That's-
what's the other
The other
issue?
issues at play, and again, I hate to harken back to these two buckets, but it really is, right? After the bond was, the bond issued supposedly a payment to West Bend, which is also a somewhat of a factual dispute. We've asked for the check that was actually written, a copy of the check that was written to the
Okay, let's
consolidated
stop it.
pipe.
Do you have a copy of the transfer of funds or checks?
Judge, I requested that from West Bend, and they were able to send me like a screenshot today showing where essentially, I think a screenshot of their bank account maybe showing that it cleared, and I think they requested it from their bank, but the bank doesn't have a copy of it to give to them, probably because it's been 8 years. I don't know, but either way, they said that they don't have an actual copy of the check, but they did send me essentially a screenshot of their account showing that with the check number and the amount paid to Consolidated,
Okay, so
and
they
then
have that
show
out.
check
What
cleared.
else do you need?
It's within their internal ledger, and we also would never received any sort of release or proof that the underlying claim was ever released or there was a lien release. But again, that's just maybe a segue into the second bucket, which is the parties may very well went into a brand new deal. This installment agreement that the Fletchers were then making payments to West Bend, admittedly so. We believe that I would like some more time to prove to the court, not only the first set of circumstances and facts that you're trying to get at, as far as, are they owed any sort of offset? Did they make any sort of payments that would have eroded that claim that they're making? And the second one is, once the Fletcher started making payments, was that a novation? Did that create a brand new contract with brand new terms? Because part of this, Judge, is that they're asking for attorney's fees and interest owing pre and post judgment interest, but and a lot of that is derived from the original indemnity agreement. And so after this claim was paid to Consolidated Pipe, supposedly, again, we've not seen the actual check that was written or a release that Consolidated Pipe granted to the surety company or my clients. But then afterwards, once there was an agreement that was sent out and said, hey, we're here and we're going to try to collect on this payment that we've made to one of your suppliers. What can you do? And then they start making partial payments and actually send
Did
them.
that happen?
It did.
Well, have you got proof of that?
Yes. Yes, we
I
did.
haven't seen.
And again, Judge, if we'd had adequate time to
You're going
bolster
to get
this.
adequate time, but look, you've had years. There've been years. How long have you been involved in this case?
I got into it last year, Judge.
Last year is
That-
the operative word, so I want
That's right,
some,
Judge.
wait. I want some action done. I'm tired of fooling with this case. Your clients need to put up or shut up, okay? And I want some proof on what you say on payments that they made or payments. I mean, you surely don't think that someone's gonna try to come back on them and collect for this material that they allegedly didn't furnish. It's been paid off. And now the bonding company paid it off and they want their money back. Okay, now if you can show where your clients paid any of that debt before the bonding company do, I'll give you an offset for it. Okay, if you can prove that they made payments after that to the bonding company, you say they made payments to the bonding company? Is that
Yes.
who they made payment? If they do, then we'll address that issue. But at this juncture, the motion for summary judgment is up and you haven't given me anything to go your way on at this juncture, and you got 10 days to do it. Okay, thank you very much.
And Judge, may we have 7 days to reply?
How many?
7 days after?
Yeah, you have 7 days to reply. Thank you very much, everybody.
Thank you, Judge.
That's all I have.
Yeah, absolutely. Have a safe journey. Shootman versus Housing Authority of Burkesville.
Yes, sir, Your Honor. Matt Cook for the Defendant Housing Authority.
Yeah. Yeah. Mr. Cross is here. Mr. Cross, you have filed a response to motion for summary judgment today.
Yesterday.
I got it today, so.
Sorry, it was filed as the rules require yesterday.
Okay.
I received it yesterday afternoon, Your Honor.
Okay, now what do y'all have to say about this? This is
Um,
tar paper coming through the crack of the ramp case. Is that right?
That's exactly right. And I've cited in my motion.
Wait, you're gonna have to speak louder. Turn it up somewhat.
All right, can you hear me now?
Yes.
All right. Yes, sir. This is a case, and I've cited in my motion, the law that.
Wait just a second, it doesn't help him coming up here. Get him some of these earphones. We're gonna have to get some earphones for Mr. Cross.
Judge, I apologize for not
Wait just a
being
second,
there.
wait just a
got
second,
over-
wait just a second. We're gonna get some earphones.
Okay.
Say something now.
Yes, sir. Can you hear me okay?
Okay, go ahead.
All right. And first of all, let me apologize for not being there. I just got over
That's
surgery.
okay.
So
Move on, move on.
all right. Yes, sir. All right. I've cited in my motion that a landlord is not liable for injuries caused by defects in leased premises unless the condition is unknown to the tenant and not discoverable through reasonable inspection. In her deposition, the plaintiff here told us she was aware of this material sticking up from the ramp, never reported it to her landlord, never asked for a repair, and therefore we feel like summary judgment is warranted based on the fact that she admits she was on notice and took no action to request any sort of repair.
What do you say, Mr. Cross?
Your Honor, I appreciate Mr. Cook's motion and I understand defense counsel.
You go ahead and speak up too.
Okay, I'm sorry. I'll do my best. I can hear myself really well. If you take everything that he says is correct, which it's not necessarily correct in this case, two problems. Number one, the slope is not according to standard, and we filed photographs. I was real surprised when I got out to Oakland Heights and I looked at Ms. Shootman's ramp. It's steeper than the ones across the road. And we have to get into discovery and do that. And number two is the rail broke. The rail's never been fixed, by the way. It's been repaired, but it's never been
The
replaced.
rail
So,
broke during this fall.
yeah, yes. See, she fell and tried to catch herself on the railing and it broke. So I understand Mr. Cook's argument, but it fails, and we'll get into it. I've sent him some, no, I've got to depose his maintenance guy and whoever move forward.
May I respond?
Sure.
I'll just point out this case has been pending for over 2 years, and prior to yesterday, I never had any request to produce anybody for a deposition. I think Ms. Shootman, the plaintiff's deposition, is dispositive on this issue under the landlord-tenant law, and I don't see how any other discovery is going to change what she's already testified to.
Your Honor, I'm going to ask their maintenance guy why there's the slope. I've made my point. I understand.
The ramp wasn't up to code is what you're
Yes,
saying, and the
and-
rail wasn't up to
It's
code, and it gave way is what you're saying.
Correct. Enough said.
And I read the deposition. She was going down with a cane as to whether she was left-handed or right-handed and that sort of thing. So, but I will tell you that it's a little difficult for me to continue to have these cases that have been languishing around for 2 years and no discoveries, and then happen or anything happens till a motion for summary judgment happens and then they get going. So I'm going to give you some days to take discovery.
Thank you.
Now, I will think that his motion, on the set of facts that he has present, that he makes a pretty good argument about that. But the slope and the improper building of the rail could change that, but very close to a summary judgment. Now, how many days do you need to finish your depositions and things? 30 days?
No. March is a bad month. What about, I request 90.
No, I'm not going to do nothing.
I guess I'll take whatever you say.
45, okay?
All right.
You have all your discovery finished in 45 days, and we'll come back here. I guess you'll have to wait, counsel, to see if he does any discovery that touches anything, and then you might ask for some additional time when you do that. If not, we'll schedule it for May the 28th. How about May the 28th?
Now, point of clarification, Your Honor, do you want, regard to my expert, do you want their report tendered in the file prior to then, or? do you want
Well,
me to
you're
take your
going to
deputy?
depose your expert, aren't you?
Well, It's going to, no, I wanted them to depose my expert. I'll bring
Well,
them
who
to
is
trial.
your expert?
That's to be identified.
So you don't have an expert, that's
After,
it.
after we take their
So you don't
deposition.
have an expert and you don't really know what happened on the rail or the ramp, but
I've
you're
been out
hoping
there.
something did.
I've been out there, Mr. Cook has
I
not been.
understand.
Yeah.
I understand what you've got. And you've got, my favorite term is a stew that was made out of a shadow of a crow that starved to death. That's what you got up to this point, but you're hoping it'll fizzle out. So, okay, you got 45 days to complete your discovery and you need to notify him within, let's say, 30 days on who your expert
Fair
is.
enough.
Okay, 30 days. And counsel, if you'll draw the motion, counsel of plaintiff, draw my order up and submit it. 30 days to give him the name of your expert and a report, and 45 days, which the 30 is inside of that, to finish your discovery. Okay?
Now, are you overruling his motion at this time?
I'm holding it in abeyance.
Let's just overrule it.
Well, the thing about, we're not making the ruling. I'm making the ruling and I'm not overruling.
Thank you, Judge.
Okay, okay, thank you. Connor versus Honeycutt.
Tell me here.
Honeycutt's here on Zoom from Grayson County.
Can you turn your camera on? There you are. Okay, I got you. This is 24 CI 0038. Is the motion for surname change. Ms. Capps is representing the plaintiff or the petitioner. And Mr. Honeycutt